Welcome, everyone. I'm Eloise Scottford. I'm the Dean of the Faculty of Laws at UCL. Welcome to this very special occasion in our faculty's academic event schedule, the first lecture in the Quain lecture series for 2025. My colleague, Professor Jeff King, will shortly introduce this week's Quain lecturer. But before he does, come in, Rob. Take a seat. I would like to say a few introductory words about the lecture series and its importance to the faculty. The Quain lectures were established in 2012 with the purpose of inviting to the faculty a leading figure in moral, legal, or political philosophy to develop a fresh set of ideas on a topic of their choosing. Previous Quain lecturers have included Philip Pettit, Joseph Raz, John Gardner, Cass Sunstein, Peter Railton, and Amir Srinivasan. Next year's Quain lecturer, this is a plug for next year already, is Shauna Schifrin. But this year we have the very eminent Professor Jeremy Waldon. The Quain lectures are a flagship initiative in the faculty and reflect its commitment to the importance of the relationship between law and philosophy. And it's lovely to see quite a few philosophy colleagues in the audience this evening. The importance of that relationship between law and philosophy is evident in related initiatives at UCL that we've curated and supported in recent years. The Institute for Law, Politics and Philosophy, which was inaugurated in 2016. It's a joint initiative of laws, philosophy and politics at UCL, and it has held over 50 seminars since its founding. We also host the UCL Quain Centre for Jurisprudence, which has hosted a broad range of seminars and related activities in the field of general jurisprudence. Other centres, such as the Global Centre for Democratic Constitutionalism, also hold a wide range of events exploring constitutional theory of democratic government and the rule of law, which has a lot of things to explore at the current moment. We also have jurisprudence as a compulsory element of our law degree, which is not something that every law faculty can claim. Professor Waldron will deliver 3 lectures this week. The first one today, followed by a drinks reception. The second is at 1 p.m. on Wednesday, and the final lecture is at 6 p.m. on Thursday. Part of the challenge of this series is obviously delivering an extraordinary lecture, so the real challenge is Jeremy's, but also for us, turning up to be in the right place at the right time. So I wish you all luck. On Friday, it's not over then. You don't get to go home yet. Still got to stay for one more day. On Friday, we hold a seminar on the lectures in which our distinguished guests, Professor David Enoch, Mitch Berman, and Nina Varsava, will offer critical thoughts on the lectures and hear from Jeremy in reply before we open the floor for discussion. This year's lectures have been organised by my wonderful colleagues, Professor Jeff King, who you'll hear about, and Professor Kevin Toe, who's here at the front, with the support of our exceptional events team, in particular Laura Howells, who's over here, and Lisa Penfold. And I just wanted to take this opportunity to really thank them for all of their hard work. So now I am going to hand over to Jeff, who is going to do the job of chairing this evening's lecture. I wish you all a wonderful week. This is a real academic treat. I think your job is to sit back and enjoy, with a moment for critical engagement on Friday. Thanks, Jeff.
Thank you, Eloise. Such is our commitment to the environment here at UCL Laws that I haven't even printed up my remarks that I'm going to deliver just now. So I am truly delighted to introduce Professor Jeremy Waldron, University Professor of Law at NYU Law School, where he teaches legal and political philosophy. Jeremy was also previously the Chicheley Professor of Political Theory at All Souls College, Oxford. And some moons ago, he finished his graduate studies and teaching in Oxford before moving to the University of Edinburgh to commence teaching jurisprudence. He then took up a series of posts in the United States, commencing at Berkeley in 1986, moving to Princeton for a brief period, and then to Columbia University for a while before going to NYU. Now, the Quain lectures have something of an identity crisis. It's a series that is at times concerned with general jurisprudence on the one hand, and at others with political theory. And Jeremy is the perfect speaker for helping us manage this crisis, because he's consistently made noted contributions to both fields And as importantly, he's put both disciplines in conversation with one another, just as did his also distinguished predecessor lecturers here, Ronald Dworkin and Joseph Raz. Professor Waldron has made his contributions in diverse ways. One is through a collection of profound books on core values in moral and political theory. These include his early study on the right to property, his book entitled God, Locke, and Equality, his Tanner lectures published as Dignity, Rank, and Rights, and his more recent book on equality, One Another's Equals. His work is also known, however, for connecting deep political theory and legal philosophy to pressing political concerns. So his book, Law and Disagreement, which contains the broader foundations of his well-known critique of constitutional judicial review, was published in 1999, right at the height of what was then called the Rights Revolution. And his Torture, Terror, and Trade-offs, A Philosophy for the White House, was not accidentally relevant to US and UK foreign policy upon its publication in 2010. His collection of essays entitled Political Theory is not so much a plea for, but rather a demonstration of how political theorists can and should take account of the subtle operations of political institutions when they theorize about what their role should be. Now, Jeremy's work exemplifies just that attitude in the 2+ recent decades of deep writing on the rule of law. This body of work spans many articles. His Hamlin lectures on the rule of law and the measure of property in 2012, and most recently his collected essays entitled Thoughtfulness and the Rule of Law, which was published by Harvard University Press just last year. In one of those essays in that book, The Concept and Rule of Law, Jeremy shows how the general concept of law sheds crucial explanatory light on the character of one of our most cherished political values. And that approach exemplifies the enlightening relationship between general jurisprudence and political theory. Similarly, thinking about the topics of his lectures this week, they promise to take us from the foundational and analytical questions about the character of legal principles to a reflection on what that tells us about the nature of grand principles in political argument. So I fear that by the end of these Quain lectures, Jeremy will have caused us to lose any will to resolve our identity crisis with the Quain lectures. And with that, I'm going to hand over to you now, Jeremy. So please join me in welcoming our speaker.
It's wonderful to be here. I haven't been in this room. I've been at UCL many times, but in this bunker, where you have to go through several elevators to get here. It's a real pleasure and a privilege to be invited to give the Quain lectures, and I'm mindful of the tradition that you've established of great speakers, and I'll try and live up to that. Listen, nothing makes a legal argument look as good as the citation of what we might call a principle to bolster its reasoning. Principles sparkle like jewels in the midst of a tedious array of texts, precedents, rules, and standards. The phraseology of principles adorns our jurisprudence. We talk about our cherished principles, our fundamental principles, our sacred principles. We admire somebody who acts on principle, who adopts a principled position, who behaves as a man or a woman of principle. We say that some issue is a matter of principle, and we hope that it will be assigned for decision to what Ronnie Dworkin has called a forum of principle. Principles matter. In the jurisprudence of the mid-20th century, when American legal theorists began to emphasize the role of principles in their arguments, the emphasis was thought to restore to legal argument a degree of rationality, a modicum of respect for reason after the excesses and the iconoclasm of the legal realist movement. To the realists, everything seemed like the indulgence of preferences. Everything seemed problematic in that way. But having judges' discretion be guided or even superseded by the consecrated principles of the corpus juris might give legitimacy to decisions that were not fully governed by texts and rules and that otherwise seemed to depend on the personal preferences of the judges. If we could only say it's not their preferences that are doing the work here, it's the principles that they have identified and that they're applying. But here's the thing, how do we know that we are dealing with a genuine legal principle? I'm not sure. There isn't much on this in the legal literature. One commentator who has lamented the lack of work on legal principles puts it this way:
Our understanding of what a principle is has a persistent scent of, well, I know it when I see it. When we identify some directive proposition as a principle, we do so in virtue of the impression it leaves us with and the quality of justice that it puts on display. It says something like, pacta sunt servanda, contracts must be kept. It says something like, intentional wrongdoing is worse than reckless wrongdoing. Or, a person in a powerful position must not take unfair advantage of another's economic necessity. Or it says, the demands of corrective justice are not to be offset by requirements of distributive justice. Legal principles have the solemnity of moral admonition, but as these examples show, they also embody concerns that are distinctively legal in character. These are not issues that come up in ordinary moral life. These are issues about the organisation of the law. Unlike a moral principle, a legal principle works in the legal habitat. But unlike a legal rule, whose formulation tells us what exactly to do under specified conditions, a legal principle identifies something as just or unjust in a sort of non-conclusory way. It argues for this or it argues for that. And it does so not with the settled text of a formulated provision, but in a way that shimmers with alternative formulations, different ways of awakening the concerns that it puts into play. With all their informality, principles crop up in cases large and small. They crop up in relatively small-scale disputes like one that I'll spend a lot of time with this evening, the famous dispute in Riggs and Palmer from 1889 in the courts of New York, the case of a legacy fought out in upstate New York. But they figure also in large constitutional issues, like the issue of presidential immunity that the United States Supreme Court decided last year in Trump against the United States. In Lecture 3, I'm going to focus on that decision, ending up with a rather disconcerting account of how grand political principles like these are produced and formulated, constructed almost to order, purpose-built to fill out legal arguments, and that's my worry. So what are legal principles? Okay, here's a mischievous answer. A legal principle is a solemn-sounding proposition that a jurist makes up, invoking it in legal argument to justify a desired outcome that might be inaccessible on the basis of other accredited sources of law. We have the position that the person wants to get to. We have the rules and texts that he's so far assembled, and there's a gap between those two. And in the 1930s and 40s, we used to say that that gap was solved by discretion or the preferences of the judge. Now we say it's solved by a principle. Well, what does that mean? It means that we have constructed a verbal bridge across the gap from the existing materials to the verdict we want to argue for. And that's what principles do. They fill in that gap. And we make them up to do that work. This initial skepticism, I'm going to take it very seriously, if only in a Cartesian spirit, to see whether it's possible in the midst of adversarial argument to secure any better understanding of what principles are, where they come from, how quarrels over them arise, and how, if we know this, how those quarrels are settled. We can't really account for the work that principles do unless we confront the many sources of skeptical concern about the role they play in adversarial legal argument. Because remember, our opponents are trying to bridge the gap in their argument between the existing materials and the position they want to reach. And so whenever we delve into the realm of principles, we are always aware that somebody is delving by our side for exactly opposite effects. Okay, now these are the Quain lectures. And Ronald Dworkin, the supervisor of my doctoral studies at Oxford, and in later years, my dear friend and colleague at NYU, Dworkin was for a considerable time Quain Professor of Jurisprudence at UCL. And it's appropriate in these lectures that I should refer to and draw on and to some extent criticize the seminal work that Dworkin did on principles very early in his career, the 1960s. I want to avoid as far as possible the tired question of the validity or otherwise of Dworkin's critique of legal positivism. Still, I want to focus on what Dworkin said affirmatively about principles and the work that they do in the law. And what I say here is going to be dedicated to Dworkin's memory. The jurisprudence that I'll set out will follow up some lines of thought that Dworkin pioneered in his essay, The Model of Rules, which is chapter 2 of Taking Rights Seriously. And the lectures this evening will also highlight some difficulties with that idea, difficulties that I know Professor Dworkin noticed, but never fully came to terms with. I have a great deal of admiration for Dworkin's work. I'm known for my admiration to this dear friend of mine. And I think there's no better way of following through on that admiration than engaging critically with his view of legal principles. I've long thought that what I want to do in my few remaining minutes in the Legal Academy is to try to engage successively with various themes in Dworkin's work as a sort of filial tribute to the man. So, again, what are legal principles? Well, what does Dworkin say about them? Dworkin contrasts them with rules, like those defining a speed limit. If you drive over 70 miles an hour, you will get a fine of £200, something like that. In a rule, we find a descriptive or numerical or otherwise determinate predicate in the norm condition, driving in excess of 70 miles an hour, nothing clearer than that. And again, in the norm consequence, to be fined £200, so that it's clear what is to happen in exactly what specified conditions. Whereas principles present themselves in a manner that is looser than that, engaging a judgment of reasonableness or fairness or rational appropriateness to determine how it is to be applied. In this respect, a principle is like a standard. A standard is an enacted norm that has some element of fairness or justice or appropriateness, except, so in that sense, a principle is like a standard, except it's not always easy to tell, and this is the second difference between rules and principles. Principles have no canonical formulation. They have no text. They have no canonical formulation. Standards do. Think of the 8th Amendment to the United States Constitution with its formulated ban on cruel and unusual punishment. We have the text there, cruel and unusual punishment. The text is canonical. It's clear even if its application is disputed. With principles, we don't even have textual clarity. This is partly the result of, and this is third difference, about the way that principles make their appearance in the law. They're not enacted. They're not laid down by anybody. They emerge. And when they do, and this is the fourth point, it seems that principles operate normatively in a way that rules do not. Rules have, so it's said, an all or nothing application. And standards do so too, even when their application remains contested. Whereas principles sort of have weight, and like reasons for action, they apply in a competitively non-conclusory way with other weighty considerations, in the way that reasons do. And they bear with greater or lesser practical force in the matter under dispute. I hope all this is familiar, if not from Dworkin's early jurisprudence, then from Henry Hart and Albert Sachs's great book, The Legal Process Materials, much underrated volume of legal theory, in my opinion. So that's the sort of the background contrast that I have in mind. And those elements, those four elements that I mentioned, again, I'm going to come back to them again and again. Let's go to our example. The title of this evening's lecture, Taking Rigs Seriously, alludes to a case brought in the state of New York by a Mrs. Loretta Riggs. Actually, Mrs. Riggs was one of two plaintiffs, sisters, in what has become, at least in the United States, a very famous case, Riggs against Palmer, decided in New York by the state's highest court in 1889. The sisters' lawsuit involved a challenge to dispositions under an apparently valid will made by their father, purporting to confer property on their nephew, grandson, a young man who had been held criminally responsible for the death of the testator. He killed the testator and now he's claiming property under the will. That a killer should inherit from his victim seemed to shock the conscience. It certainly shocked the conscience of Loretta and her sister, who stood to benefit if the young man could be excluded. But inheritance by a person who happened to be the testator's killer. This is what the will provided. The will was clear, it was properly executed. And so that was the problem. That's Riggs, Loretta Riggs, bringing the suit against the application of the will. Palmer, Riggs against Palmer. Palmer was Elmer Palmer, the nephew of Loretta Riggs and the grandson of Loretta's father, Francis. The grandfather owned a farm in the far north of upstate New York. Elmer lived on the farm with his mother, who was a third sister. It's well known that Francis Palmer, the grandfather, had made a will that left the farm to Elmer. Everybody knew that, though the two did not always get along, and Francis would occasionally talk about revoking his grandson's inheritance if the boy did not mend his ways. One day in April 1882, the old man died, aged 66. Died suddenly after drinking rum that had been spiked with strychnine. The poisoning was investigated and a grand jury indicted Elmer for first-degree murder. He pleaded not guilty, and in October he went on trial. Most of the evidence was circumstantial. The grandson claimed that the poisoning was accidental, and witnesses were brought in to testify to his good character. But after 12 hours of deliberation, a jury convicted Elmer of second-degree murder. Now, second-degree murder, that meant he was not eligible for the death penalty, but he was eligible for life imprisonment. In fact, he was very lucky in his judge. He was sentenced to indefinite detention at a new penal facility in Elmira, New York, which had been established as a reformatory for adults with, it has to be said, a very flexible philosophy of penitential servitude. Elmer fell in so well with the reformatory's program of work and training and education that he found himself released on parole in 1886, 4 years after the murder, a discharge that was made absolute a few months after that. It's a remarkable disposition of a murder case. But it gave him the opportunity now to claim his inheritance, which is what he wanted all along. Outraged, no doubt, by the young man's early release and by his insouciant claiming of his inheritance, Elmer's aunt, Loretta Riggs, sued to deny that to him. At first instance and second instance, the New York courts ruled that the clear terms of the grandfather's will had to be honoured. The court said that the law relating to wills was perfectly clear and disclosed no exception that could justify depriving him of his legacy. So far, so good for young Mr. Palmer. But then the Court of Appeals, the highest court in the state, ruled differently. By 3 votes to 2, the New York Court of Appeals ruled against Palmer, with Judge Robert Earl and 2 others holding that a case like this was controlled by, the phrase they used was, general fundamental maxims of the common law. General fundamental maxims of the common law. The judge didn't use the word principles, but that was what he meant. He said this: "No one shall be permitted to profit by his own fraud, or to take advantage of his own wrong, or to found any claim upon his own iniquity, or to acquire property by his own crime. These maxims are dictated by public policy. They have their foundation in universal law administered in all civilized countries, and they have nowhere been superseded by statutes. These maxims, without any statute giving them force or operation, frequently control the effect and nullify the language of wills." And they used an appeal to those principles, those various formulations, to deny Elmer his inheritance. So we call what Judge Earl cited a principle. And though it was an unenacted legal proposition, not enacted by a legislature, the court said that this principle expressed the spirit of New York law. It expressed the spirit of the law, and as such it was binding on the judges of any court. They were not to permit any person to profit by his own crime in this way. That's what the majority held. It was as though they had invoked a principle of natural law. It's not quite natural law because we're talking about a legal principle, a principle deeply embedded in the fabric of New York law and perhaps in the fabric of other legal systems as well. This principle about not profiting from your own wrong, I'm going to call it the wrongdoing principle. That's what I will mean, that you're not to profit from your own wrongdoing. It wasn't the only justification cited for the court's decision. They also said, look, sometimes you have a statute and it says something is okay which patently isn't okay because the lawmakers hadn't thought of this particular situation. But if they had thought of it, then hypothetically they would have altered the terms of the statute. And certainly there was a case for saying that in this case. Probably the people who wrote the statute of wills, not to mention the statute of homicide in New York State, had never given any thought to this bizarre possibility that a young poisoner would be claiming under an otherwise valid will. But if they had given any thought to it, then maybe the statute would have been written differently. So the courts are entitled to perhaps rewrite the statute to say what the court would have said. Brian Leiter, who teaches legal philosophy at the University of Chicago, says of these two arguments, one about principles, one about the hypothetical attitudes of the legislators, of these two explanations, these two approaches, Dworkin really mostly favoured the second, the one about the hypothetical attitudes of the judges, of the legislators. I think that's wrong. I think Dworkin was particularly interested in the legal principles argument, and that's what I'm focusing on this evening. Apart from anything else, even though I'm not interested in it, Dworkin was interested in trying to embarrass legal positivists by pointing to forms and provisions in the law that have a presence in the law even though they've not been enacted, and even though they're not subject to a rule of recognition. That's why he was interested in principles, not in this other point, which of course also reinforced the position about what the legislators would have done had they contemplated this possibility. I said that Judge Earle didn't describe the proposition in question as a principle, but a principle seems to be what was being invoked here, with the moralistic overtones of the predicates it used. No one should profit by his own wrongdoing, with the emphasis placed on the pervasive character of its invocation, upheld by all civilized legal systems, and with the invitation on its emphasis on its concededly unenacted character, and with its subsequent looseness of formulation from context to context. One way or another, at any rate, Francis Palmer's poisoner was excluded. The Court of Appeals, in the final decision, nullified the application of an otherwise valid will, finding in favour of the deceased man's daughters. Alma surrendered the farm to Loretta. He then moved to Canada, which was just a few yards away from where he grew up in New York, and raised a family, and subsequently seems to have lived an exemplary life in Ontario until he died at the age of 69. A lot more could be said about this case. I've tried to say quite a bit about it this evening just to give us some vivid colour for thinking about principles. Was the Court of Appeals influenced by the light sentence that Alma had received for the original homicide? Was there an additional principle at stake which mentioned crimes that had not properly been requited under existing criminal law? In a subsequent case, the New York court did not allow the wrongdoing principle could simply block a murderer's inheritance. Instead, they said they were entitled to limit what the murderer could do with the estate, imposing on it the limits of a constructive trust. And that, as we will see, is the thing about principles. They sort of shimmer with different formulations. Here, they were thinking about the different formulations that have to do with what the court could order with regard to the inheritance. Having no canonical formulation, each term could only have a suggestive implication. It could apply to somebody inheriting or receiving the benefit of a life assurance policy, or somebody winning in a custody dispute. Just think, a father kidnaps a child during a custody dispute, and after a year or so is brought back into the court of the original jurisdiction for proper decision with the custody dispute. The father now sets up the bond that he has formed with the young child as a basis for his case in the resolution of the custody dispute. That seems to be a case of profiting from his own wrongdoing for the purpose of the settlement of the dispute. Or it could be enjoying property with or without limitations, or being so bound on the basis of wrongdoing and moral iniquity or crime or fraud specifically. And which of those terms applies? Is it wrongdoing? Is it crime? Is it fraud? Is it moral iniquity? Somebody secures property under a will by virtue of their adultery. They break up somebody's marriage and they acquire the the benefit of property from the married couple. Would that count as a basis for the application of this principle? It's important to understand what exactly the wrongdoing principle does in Riggs against Palmer, and this is important. It wasn't really a way of resolving what Dworkin might call a hard case, a case in which the application of existing law was unclear or indeterminate. Apart from the operation of the principle cited by the majority, Riggs against Palmer was an easy case. Yeah? The statute of wills was perfectly clear. There was nothing about the behaviour of the testator that indicated he wanted to rewrite his will. It was an easy case. It posed an issue of conscience, but not an issue of law. The grandfather's will was properly executed by a competent testator, and nothing about the existing criminal law made the grandson's inheritance problematic. The grandson was already serving his sentence for homicide, paying his debt to society, as we say. There was no provision for any alternative penalty such as expropriation, attainder, or civil death. The case became hard only because the wrongdoing principle seemed to have a bearing on it. It was the principle that made the case hard. It wasn't the principle that resolved the hardness of the case. It was the principle that made the case hard, or perhaps the discomfiture that surfaced in the form of the principle. And then, once the case had become hard, the difficulty was resolved not just by the discernment and application of the wrongdoing principle, but by the majorities figuring out the comparative weight of all the principles that were involved in this case. In this case, a judgment that the wrongdoing principle had greater weight in the circumstances than another principle we might summon up, which demanded that proper effect be given to legislation like the statute of wills. Proper effect be given to it according to its terms for the sake of certainty or predictability or security. We believe that's an important principle of law as well, that legislation should be enforced according to its terms. Or the legislation that says the penalties for murder should be made very clear in advance, not just made up when the court is dissatisfied with the way things have turned out. So in all these cases, in all these situations, we're likely to have not just the legal principle that we have dredged up from the history of jurisprudence, but other legal principles that are operating to bolster the claims of statutes and the claims of legislation. The dissenting judges, and there were 2 dissenting judges in Riggs against Palmer, the dissenting judges thought that even if there were something like the wrongdoing principle in play, it carried less weight than the principle asserting the authority of statute law. In general, or certainly on a matter such as testamentary law, said Judge John Gray in dissent, "We are bound by rigid rules of law which have been established by the legislature. The question we are dealing with is whether a testamentary disposition can be altered after the testator's death through an appeal to the courts, when the legislature has by its enactments prescribed exactly when and how wills may be made and altered and revoked." The whole of the subject is now governed by statute. That's what the dissenters said. They weren't pushing principles aside, they were citing an alternative set of principles. And Judge Gray's dissent reminds us, and this is very important, it reminds us of the adversarial dimension of the invocation of principles. In law, we do things in twos. We do things adversarially. I try to make my argument, you try to make your argument, and we present that to a tribunal. And when a judge writes a decision, when the judge writes an opinion, the judge writes the opinion and he puts that forward to confront the opinion written by his dissenting brethren on the court. Adversarial character of decision-making all along, and that's as important in the area of principles as it is in the area of statutes. You see, the invocation of the wrongdoing principle sounds all very high-minded compared to the grubby positivity of statute law. The principle of wrongdoing glows with moral rectitude, and it claims a foundation in universal law administered in all civilized countries. But the competing principle about the authority of statute law seems equally aglow, equally fundamental, disclosing a general principle of deference to legitimate textual enactments. It's a very important principle for someone like me, who has written books called The Dignity of Legislation, who takes legislation very seriously. So the position of the dissenting judgment is not just a pedantic, blinkered, or arbitrary refusal to concede the normative bearing of the Riggs principle. There are principles on both sides. If we want to talk about arbitrariness, either the majority or the dissent might be seen as making an arbitrary choice among several principles, equally fundamental, equally important, and all purpose-built to support their respective conclusions. The matter is settled actually finally by voting. 3 people vote yes, 2 people vote no. Maybe that's not arbitrary, but it's certainly not the most principled measure. It's commonly said that principles have no canonical formulation, and this is going to be crucial to my argument in all these lectures. No canonical formulation, so they're not to be parsed textually as a statutory rule might be. This means that if in a complex matter different and rival formulations are in play, and if the various formulations point in subtly or grossly different dimensions, there will be no sense, no clear sense, no given sense of priority or authoritative ordering among them. We can see this in our example from the language used in Riggs against Palmer. What's the crux of the wrongdoing principle supposed to be? Is it about crime, inequity, fraud, moral turpitude, or what? What's the basis on which we're saying a person who does this shall not be permitted to profit for his own advantage? Well, you might say, come on, Waldon, murder at any rate is pretty bad. It doesn't apply to murder, it's not clear what it would apply to. But even here some difficulty comes to light from the subsequent history of the wrongdoing principle. Some legal systems have found it wise or necessary to actually pass a statutory enactment to express the force of the wrongdoing principle in Riggs against Palmer. And where legal systems have done this, there has been uncertainty and controversy about how to do it. Should the relevant legal proposition refer to all forms and degrees of homicide? How should it affect, for example, the rights of a woman convicted of a lower degree of homicide in response to domestic violence, for example? How indeed should it affect that woman's inheritance of her share of matrimonial property according to law, as opposed to the gratuitous benefit taken under a decedent's will in Riggs against Palmer, and so on? Legislative drafters have found that very difficult to parse and to think through. And I only mention that, it just indicates that the lack of any canonical formulation might actually have real costs in difficult cases. Had the jurisprudence of principles taken its rise from a case like that, I mean the domestic violence case, rather than from the more straightforward case of murderous wrongdoing in Riggs against Palmer, its bearing would be less clear, and the significance of controversy among candidate formulations and their assigned weights would have been more apparent. So there's no authoritative formulation, and that's likely to get us into difficulty over time with a given principle. The idea of non-enacted law emerging from practice or from thousands of micro-decisions in, say, a common law environment, is an intriguing and attractive one. Emergent law is an important category. Think about customary law, think about customary international law, think about the jus gentium, think about general principles of international law, the lex mercatoria, and so on. In the later work of Friedrich Hayek, positive enactment is disparaged as the upshot of a constructivist mentality, whereas unenacted law is the admirable product of social evolution, working upon social practices which embody a largely inchoate sense of fairness or appropriateness. Okay, you can have all that. The admirable product of social evolution operating on a sort of a sensibility, embodying a largely inchoate sense of fairness or appropriateness, but it's not a recipe for precision. It's not a recipe for determinate resolution of the difficulties coming up in particular cases. Putting inarticulate but deeply embedded practices into words is a real challenge, as people struggle to say out loud what they have been silently relying on in their good faith dealings with others, if the thought even occurred to them. Now, it's tempting to think that non-enacted law emerges organically from our practices as a wolf cub emerges from its mother's womb. Why did I put that in? But of course, as with all law, we humans are the midwives. We have our role to play as we preside over the emergence of formulated and unformulated principles from doctrine, practice, instinct, and custom in the course of our law work. Look, you see this with stare decisis. You see this in the law of precedent, where sometimes you're trying to look at a little formulation that the judge in the precedent case has given you, or you try to look at the formulation that has been adopted by an array of subsequent courts, or you try to look at the gravitational force that the precedent has over a large area of law, and you quickly lose your grip on anything precise in the formulations that a court has given you. So then, can anything be a legal principle? Because remember where we started, which is my worry, that a principle is just something we make up to bridge the gap between two legal propositions. Can anything be a legal principle? We know that any kind of content might be law. That's something that Hans Kelsen said. If we are lawmakers in a parliament, we can just make something up and use the majoritarian processes of legislation to give it authority, whatever it is. Can we do the same with principles? We now being litigants, not legislators, but litigants, fleshing out an argument that we want to make in court. In terms of the provocation I offered earlier, is a legal principle just an impressive sounding proposition that a judge or an attorney makes up and then invokes in legal argument, like Judge Earle's argument in Riggs against Palmer, to justify a desired outcome that might be inaccessible on the basis of accredited legal sources? Sometimes the invocation of a principle might be justified by citing an earlier decision in which the principle in question has been invoked. And there were footnotes and citations in Riggs against Palmer. But that just pushes the problem back a bit. For still we ask, where do principles come from originally? The life of a legal principle has to start somewhere. Sometimes a new principle has to be built, a new bridge has to be built, necessitating the formulation of a principle that in its terms has never been heard of because it was never needed before. What are we to do about the origins of principles? And what justifies a legal principle when there are competing proposals for principle status, or when there is concern about their formulation or about their weight or about the way they are drawn from existing materials? This question is key to my argument this evening. Listen to Dworkin's acknowledgement of the problem. Remember, although this is partly an anti-Dworkin argument, it's an argument that tries to take seriously how Dworkin responded to these difficulties. Listen to Dworkin's acknowledgement of the problem in his second book, A Matter of Principle. In such a case, he said, the plaintiff's lawyers will present an argument as to why, all things considered, his case is stronger than the defendant's. And the defendant's counsel will present a different argument, a different principled argument to the opposite effect. And at the end of the day, the judge will decide by preferring one of these two arguments, or perhaps by providing a different one of their own. I believe, says Dworkin, that even in hard cases like these, the arguments that lawyers put forward and that judges accept or reject are arguments of principle. So there's principles coming at us from every direction in these cases. What are we to say about that? Dworkin is acknowledging the prospect of there being arguments of principle on both sides. For too long, we've been satisfied in thinking about the problems of jurisprudence. Can we find a description of how legal reasoning works, which would explain why an argument seems to work to the satisfaction of the person who produces it? Can we provide a recipe for legal arguments that will produce arguments that satisfy the people who produce them? And that may be necessary for legal argumentation, but it's not sufficient, because there are likely to be alternative sets of principles, alternative sets of considerations, each of them concocted to the satisfaction of the person presenting them. What are we to say in that difficulty? Hart and Sachs, whose book, The Legal Process, I mentioned before, I don't think that the Hart and Sachs help much when they associate principles with, this is their phrase, reasons of established credit in jurisprudence. Principles, it seems, convey the force of reasons already recognised by the law. And Ronald Dworkin relied on something similar in various places as well. He said, well, look, if we were challenged to back up our claim that some principle is a principle of our law, we would mention any prior case in which the principle was cited or figured in the argument, and unless we could find such institutional support, we would probably fail to make out our case. He said this although Dworkin was anxious to avoid giving the impression that a principle could be recognised as such just by passing a certain threshold of practice and evidence in its favour. He didn't want to concede too much to the legal positivists on this, who were prepared to say, okay, so principle just is a proposition that has a certain amount of backing from existing case law. He resisted, and rightly so, conceptions that tied principles to recognisable facts about judicial custom. Not only was the room for controversy too wide, controversy about content, detail, nuance, normative weight, not only would the practice of recognition defy easy organisation into a secondary rule, but also the provenance of a particular alleged principle might be too recent to be captured by any customary version of recognition. A great many appeals to principles, said Dworkin, are appeals to principles that have not been the subject of any established judicial practice at all. That's a key concession by him. In many cases, he said, they comprise principles that have not in fact been formulated before in anything like the same fashion. I think we have to take that concession by Dworkin very seriously indeed when we contemplate the role that principles can play in adversarial argument. A further basis, I'm just going to grab a little bit of water here. Thank you. A further basis for thinking about the origin of principles is to say, well, they have their origin in a sense of intuitive fairness or intuitive reasonableness. And that's really what's going on to justify a principle. And no doubt something like that is true. Dworkin said, if it no longer seemed unfair to allow people to profit from their own wrongdoing, that principle would no longer play much of a role in new cases. If we find that intuitions have changed over time, then that will affect what principles are regarded as respectable for people to cite in new cases. In this discussion in Law's Empire about whether we should regard the Nazis as having law, Dworkin says that certain principles could have no justifying power in any acceptable political morality, and he thought that Nazi principles would be like that. But of course the Nazi example is too easy. The morality is atrocious, and in any case it's not ours. What happens though when we try to extrapolate principles from a body of law that has to be acknowledged as ours, but is nevertheless riven with bitter partisan divides? Think of the role of racial considerations in American law over the past 200 years. Think of the principles that Chief Justice Tawney was able to dredge up in the Dred Scott case in 1856 concerning the possible citizenship rights of African Americans. Think of the intuitions that he was appealing to for those principles that he appeared to be relying on. The principles that Tawney cited are to our ears egregious and appalling, but it's hard to ignore the fact that there was enough in our law then to license such extrapolations which might pass any test of intuitive plausibility administered at that time. Is this a fair instance of how principles are produced? Look, the most important reason why we cannot demand that the principles we recognise must be intuitively appealing is that principles are supposed to emerge from the law as a whole, and the law as a whole has not been under the influence of just one person's intuitions, or the intuitions solely of a class of persons with whom we identify. In these matters, the beginning of wisdom, and I have made this the theme of almost all of my work in jurisprudence and political theory, the beginning of wisdom is that we share a legal world with those with whom we disagree morally. We share a legal world with those whose intuitions do not coincide with our intuitions. And we can't expect principles that are supposed to emerge from law laid down first on this side and then on that side to be morally congenial both to ourselves and our moral opponents. And those oppositions may crystallize in the adversarial proceedings that come up in particular cases. Joseph Raz put the same point very well when he said, look, law is the result of the rough and tumble of politics, and it reflects the changing fortunes of political forces. There's no reason to expect the law to be coherent. There's bits and pieces of law all over the place. And this may ultimately be why talk of legal principles is problematic. We share the legal system with people who disagree with us about political morality, about rights, justice, the public good, morality, inequity, and so on. They have their principles, we have ours. In a legal system that lasts longer than a few weeks, victories for my side will be matched for victories for my opponent's side. When I win, I can recognize my principles or something like them in certain legal or judicial outcomes. Because I endorse them, I'll be comfortable calling them either moral principles, mine, or legal principles, the community's, or both. When my opponents win, I won't be comfortable calling the resulting principles moral principles, except in a third person sense. This is their morality. But I will have to recognize them as legal principles on account of their position in the law. In this sense, legal principles don't have to be moral principles. This approach seems to depend on my opponents holding a set of recognizably moral positions, not positions that I myself endorse as moral, but positions that are in the moral ballpark, that I can imagine being held as moral positions. Legal principles don't have the status of enacted law, but they're supposed to emerge in part from the body of enacted law, from statutes, for example, that seem to exemplify them or that invoke them in their preamble. And therefore, as emergent phenomena, their character is, so to speak, partly at the mercy of the content and consistency of existing law. Some of what emerges may be morally familiar. It might represent some high-minded adage of morality that we can subscribe to. But other things that emerge from a given legal system in a complex, partisan society might be understood not in those glowing terms, but in terms of what we view as the idiosyncrasies and perversities and contradictions of the enacted law from which they spring and whose spirit they purport to capture. Maybe this is the right time, and I'm heading towards a conclusion here. This is the right time to mention the way in which Dworkin developed his account of principles in the work that he did after the model of rules. Instead of saying that we might discern the presence of some thing called a principle in the existing body of law and take that thing out of the law and cite it in court. Instead of doing that, he thought that we might say that a principle is something we construct, actually embracing the Waldron worry about the principle being something we make up. Principle is something we make up or construct to give some unity and some coherence to existing norms of law. A proposition whose unifying function makes the existing law seem principled. My friend Stephen Perry has argued that this is one of two conceptions of what a legal principle is that Dworkin used in his early work: a discernible maxim on the one hand and a constructed unifier on the other. But this second conception faces a similar set of difficulties. Perry thinks the most important objection is that the second approach is overly conservative. We're trying to extrapolate something from the law that already exists, so that binds us to the status quo. The second approach is overly conservative, with only those principles emerging that can justify existing law. It doesn't seem to allow principles to perform any radical function. He may be right about that, but it's not the most serious objection. If principles are supposed to emerge from existing law, then I'm afraid we have to say that they are oriented towards the contents of a sort of midden. You know what I mean by a midden? Sort of a compost heap that an archaeologist will find in the rubbish dump of an ancient civilization that he sorts through. A midden is a sort of a compost heap of broken shards of pottery, bits and pieces of swords and weapons, cooking gear, and so on. We have a compost of laws enacted by last year's Liberals, last century's Conservatives, feminist legislators in the 1970s, religious advocates in the 1870s, And it's not a tidy and well-sorted midden. That's exactly what Reyes said in that earlier concert. It's at the mercy of what the politics of the society has been like. And we pick through all that to try and find something to flesh out our arguments. And as we do that, the noise we will hear is our opponent's attorney doing something exactly similar to match the requirements of the case that she is trying to make on behalf of her client. Or if, like Dworkin's archetypal judge Hercules, the judge is trying to make a principled case out of this compost, he will be conscious of working alongside his brother and sister judges or their clerks, trying to do something similar, parallel but in the opposite direction, in behalf of his bitter opponents on the bench. So that's a worry that I have about principles. Given what they are, it's difficult to see how they can reliably or determinately operate. And given what they are, it's very difficult to see where they come from and how they can be justified. It's time to stop, but we've seen 4 themes meet up in the argument this evening. A theme of moral disagreement, which undermines any easy intuition test for principles. Secondly, the character of our legal heritage is an untidy compost or midden of opposing legal ideas. Thirdly, the looseness, or if you like, the indeterminacy of any particular principle, given that it is not presented to us canonically as an authoritative enacted text. And 4, the adversarial character of legal argument, which means that it's not enough to show that a given jurist with whom we identify can make a principled argument to his own satisfaction. He's got to tell us something about why his argument should be entitled to prevail. The life of the law is not just a set of theories concocted by solitary jurists. Dworkin's lawyer is supposed to be able to find sufficient coherence to assert credibly that the law is pervaded by principles which favour his client's case, and to exclude any similar but opposing claim made in behalf of his opponent. But why should we assume that this is possible? As Dworkin acknowledges, nothing in the way that law was produced guarantees that the lawyer or judge will succeed in finding a coherent interpretation of it. Or if he can find a coherent interpretation of the patchwork, nothing in the way that the law was produced guarantees that his success precludes similar success for his opponent, pointing towards a different conclusion. Nothing guarantees that the law has a shape amenable to a unique, coherent justification of principle. Without that guarantee, or at any rate without a reasonable prospect of a unique coherence result, the Dworkinian approach to legal argument is just a recipe. It's just a recipe for the reproduction of indeterminacy. Or rather, the introduction of principles does little to help us resolve the indeterminacy that we already face. Okay, well, thanks. On Wednesday, I want to take up an alternative account of the role that principles might play in our jurisprudence. They might play primarily a descriptive function, characterizing and denominating the qualities of our legal system rather than guiding legal decisions normatively. In this character, legal principles are not really normative, and our discussion on Wednesday will raise questions in this light about the normativity of principles in general. So I'm going to talk about these descriptive principles on Wednesday. And then on Thursday, we'll come back a little bit to the normative principles, to the great political principles that we use, like the rule of law and the separation of powers, and the difficulty we have in applying those to settle hard cases. That's it. Thank you very much indeed.